right, the next matter to come before the court is Joseph Elias versus the city of Akron. Each side will have 15 minutes to present its arguments. The appellant may reserve up to 5 minutes for rebuttal. Mr. Reese, if you want to reserve time, when you take the podium, let me know how much. I'll do my best to keep track of the clock, although I haven't exactly been award-winning today. All right, the arguments are being visually and audibly recorded to be posted online, so please keep your voices up and remain behind the podium. We are ready to proceed when you are. We have read your briefs.
Thank you. Good morning. I would like to reserve 3 minutes.
Okay.
May it please the court, my name is Christopher Reese. I represent the appellant, the city of Akron in this case. It is a highway or a road maintenance case that involves the issue of 2744 immunity in the trial court below. Before I discuss as many of my arguments as I can cram into 12 minutes, I want to start with a discussion about the trial court's opinion below. I've read it, needless to say, probably dozens of times since it was issued last summer, and I still am a bit uncertain as to how the trial court decided to treat the immunity issue that was before it. Before the court was a 2744-02B3 claim, which I'll refer to just as a B3 claim for brevity. There are 2 components to that claim in order to prove the exception to immunity. One is the case a road maintenance or repair case? And 2, is there negligence? Is there proof of negligence by the plaintiff in the case? Those are the 2 simple components of the B3 exception. In that regard, the city advanced 7 arguments on the prong of negligence. I mean, needless to say, Mr. and Mrs. Elias were injured on a city road. There's no doubt that this involves arguably city road maintenance. So the issue in the case becomes negligence. And that's why the city presented the 7 arguments to the trial court on the issue of negligence. The trial court, I made 2 holdings in that regard. One, it held that there's issues of fact as to whether the city breached its duty to repair the potentially hazardous road condition, and whether it was reasonable for the city to wait 2 days to begin the maintenance of the road. Let me make one quick point about that, though. That's a misconception by the trial court below. The city did not wait 2 days to begin the repair of this. In fact, when the first person that went to the scene, Mr. Green, saw that there was depression in the road, he immediately called his supervisor, and he called the sewer maintenance department, so the sewer maintenance department could do step 1 in the repair, which is to come out there and determine whether this is a sewer-related situation. So it's not accurate to construe the facts that the city waited 2 days to begin the repair of the road here. But
they put up any barriers or warning signs?
They did not. I'm sorry. No, they did not, Judge. Mr. Green, who went out first, determined, based on his experience in highway maintenance, he called his supervisor and he determined that the depression in the road did not pose a hazard to regular traffic.
But this is something that the city's not accustomed to doing, isn't it? I thought they contracted out with, I think it was Miller, to do their road repairs.
Well, it's a little both, Judge, and that actually jumps ahead to whether this was just routine maintenance or whether it was something over and above routine maintenance. And that goes to an argument that I wanted to touch on later, but since we're on it now, I think this is a compelling case to jump ahead to those defenses, the 05 to 03 defenses in the immunity statute. Because I think this case is in line with the Shoemaker case and the East Ohio Gas Company case that I cited in my brief, that what was going on here went beyond just routine maintenance decisions. Routine maintenance decision, if John Green would have come out there and seen a pothole in the road, it's routine maintenance to take a shovel full of cold fill and fill it in. That's routine maintenance. What this was going to require ultimately was to determine the cause of the depression, to mobilize a crew, to mobilize the equipment, to travel to the scene, to shut down the road, to excavate the site, to backfill it, and then to put a temporary cap over it. that if the city would have undertaken the repair, that's what it would entail, which I submit to you goes well beyond the routine maintenance that in case law says that the discretionary immunity does not apply to. But you're right, Your Honors. Depending on the magnitude of the job, getting back to your question, depending on the magnitude of the job, the city does contract some of that out at some point. So that's even more beyond routine maintenance if they would have had to hire a contractor to come out to do it. But anyhow, what the trial court went on to say after it found that there's a question of fact as to the breach of duty, it went on to say that the court finds that its determination on political subdivision immunity resolves the entirety of the motion, and therefore there's no need, this isn't the quote, and there's no need to address the city's 6 remaining arguments. I think the court, in my opinion, I believe the trial court erred in that holding. I don't quite follow what the trial court meant when it said the court has determined the issue of political subdivision immunity, therefore the court's not going to address the duty, whether a duty's owed, whether there was a breach of duty, whether it was a proximate cause of the injury. All those are part and parcel of the negligence analysis that's embodied in the exception. So, what is the remedy for that? I think this court, I understand that this court would have 2 options in this case. One would be to remand the case back to the trial court with instructions to rule on the remaining 6 negligence arguments. Now, whether there's a duty owed to Mr. and Mrs. Elias is an issue of law. The trial court needed to decide that issue as part of the immunity analysis. But I also understand that pursuant to de novo review, I believe this court could possibly rule on those remaining arguments now in the Court of Appeals, if in fact the court wanted to make a ruling on that. A couple of the arguments that the city made within the negligence argument. There's a long list in Ohio of inherently dangerous activities for which assumption of the risk, primary assumption of the risk applies. The city submits in this case that if you take a look at that list of things that the Ohio courts have declared to be inherently dangerous activities, I submit to you that motorcycles are an inherently dangerous mode of transportation. And particularly when motorcycles are traveling on city streets or urban streets. And we made the argument to the court below, and I now make it here, that to recognize that the mode of transportation of motorcycles should be recognized in Ohio as an inherently dangerous activity. Primary assumption of the risks that apply. The Eliases tacitly consented to any risk that was inherent in riding a motorcycle, and that was to encounter such conditions like this in an urban street. If that is in fact the trial court's ruling or this court's ruling, the case ends because you owe no duty to a person who tacitly consents to a risk such as that. The open and obvious nature of it. It's always a tricky issue in Ohio because you find that plaintiffs or claimants want to allege that there's a condition in the road that was so apparent that it required action on behalf of the city, repair action, but in turn it wasn't apparent enough for the pedestrian or the driver to appreciate it and avoid it. I submit to you that the photographs in this case indicate that this was an open and obvious condition in the street. Mrs. Elias had ample opportunity to detect it, to see it, and to avoid it like her husband did. I think the open and obvious nature of it obviates the duty of care owed to the Eliases. With regard to the status of Mrs. Elias when she was riding on the street, the city contends that she was at the status of a licensee. Mrs. Elias was on public property, and at the time of this accident, she was not conferring any benefit on the city of Akron by traveling on the streets of the city of Akron. I believe the case law supports the argument that Mrs. Elias was a licensee at this time, which then dictates the duty of care owed to Mrs. Elias, and it makes the duty of care to refrain from willful or wanton conduct as opposed to just simple ordinary care. And if this court, or the trial court, was to agree with the licensee status, I think there's one thing I can say with certainty. There is no evidence in the record that any city employee, Mr. Green, Mr. Haslam, Mr. Green or Haslam's supervisors, or anybody that had any decision-making role in this whole thing, acted willfully or wantonly. You could say a lot about city employees. I know, whatever the common thought is about government employees or public employees, I can say this. There is no evidence that somebody made a conscious decision not to they appreciated the risk that's posed in the road and made some conscious decision, some twisted decision not to do anything about it, knowing with certainty that it could cause a motorcycle accident. So if this court was to confer licensee status on Mrs. Elias, I think summary judgment is going to be proper due to the lack of evidence of willful or wanton conduct in the record. Finally, I wanted to touch on what I jumped ahead and touched on, which was the defenses in this case. Now, there was an exercise of discretion in this case, and this kind of plays into what I just mentioned about city employees. Every time that the city has a water, sewer, or highway maintenance case, it necessarily requires the exercise of discretion. All too often, there's an immediate discounting of that discretion that's exercised by a city employee. Oh, they're just city employees. Oh, they just punch in, punch out kind of thing. There was discretion used in this case with regard to the immediacy of the repair and the repair process. It was exercised by the first line employees, Mr. Haslam and Mr. Green. It was exercised by their supervisors, and I don't believe that it was exercised in bad faith or recklessly or willfully or wantonly. I think this is a case where the 03 defenses apply to reinstate immunity. Thank you.
Thank you, Your Honor. Honors, may it please the court, counsel for the appellant. We are here, as I understand it, and have been in the Court of Appeals for one reason, and one reason only, and that is to determine whether or not immunity applies. 90%, I would say at least 80% to 100% of the appellant's arguments have been based upon items that are not permitted to even be before this court. The law, as I understand it, is clear that if you're going to have an appeal immediately following a ruling for a motion for summary judgment, while the rest of the case denying the summary judgment motion, you can only appeal on the immunity issue. You cannot appeal on the fact of whether or not the facts and law justify a motion for summary judgment. When the trial court denies a motion for summary judgment, the case goes to trial, and then everything is ready for an appeal with the exception of immunity. They let immunity get a special dispensation or whatever we want to call it, that it can go directly up on an immunity question. And that isn't what is being argued at this point.
Did the court have to address the negligence arguments of the city in making its decision on immunity?
May it please the court, Your Honor, I don't think so. I mean, immunity, they're either immune or they're not, and then whether or not they're negligent would have to be addressed in the trial. If it would go back to the trial court for trial,
but the city's clearly general meets the first.
Pardon me, Your Honor?
The city clearly meets the first general immunity. Fact.
Absolutely.
Right.
You mean by statute before anything?
So then the court would go on and look at the exceptions.
Yes, sir.
Correct.
Yes, sir. No, I would agree with that. That I would not, respectfully, I would not agree with the position that the city is immune initially. I would submit that they are immune unless an exception is proven. Now, I don't know what, certainly don't want to quibble on that, but I would view it that way. I might be dead wrong. But one way or the other, they are combined with respect to the ultimate decision. If they're not going to be, if they are not going to be immune, then plaintiff has the burden of proving that there's an exception, which we respectfully believe we did.
Okay, but then the
Because it's a
analysis,
statutory exception under 2744.
doesn't the analysis then go to the defenses that could reinstate immunity?
I don't think so, Your Honor.
You don't think so?
I don't, let me rephrase it. I don't think a defense at the trial would reinstate the immunity. It would just say they won the case on the facts. They weren't immune, but they weren't negligent. I think that is the next tier.
Thank you.
That's, they cite, referred to 3 cases. This East Ohio gas case was a case where the call came in at 2:30 in the morning, and the crew was scheduled to come out at 7:30, a normal time. The person who in charge of bringing them out had a very lengthy appeal process they had to go through in offering the jobs. And they concluded that from 2:30 to 7:30, there was no sense in calling in an overtime crew because they wouldn't save any time, as I read that case. The appellant also cites, well, I'm referring to the ones they're talking about today, but I think it's the Shoemaker versus Park Lane case was one they cited. And what happened there was the city was attempting to, they had a whole bunch of water main breaks because of the drop in temperature fast, the deep, very cold. And they tried to take care of the most serious ones first. And that's what helped. And the Park Lane case wasn't one of the most serious in their judgment. And the third one they cite on that issue, and they referred to 2 today, but was Ohio Quay. They had to shut off valves, is what was the end result of the work. And they shut off as many as they could, as fast as they could get to them. And that was, in all those cases, it was held they acted properly. The question about bicycles and motorcycles, I don't think is an immunity issue, but I say bicycles and motorcycles because they're all permitted on the roadways. The people that take care of the roads know they're going to be there. And albeit this type of a hole, a single hole, is more dangerous to a two-wheel vehicle than it is a 4. But I don't think that the law is going to, that would be a whole other question, but I can't see that happening. Anything's possible in the future, but we would respectfully submit it's not an immunity question. They refer to open and obvious. Open and obvious, respectfully as I understand it, refers to primarily people standing still looking at something or walking. And I'm not trying to say that it couldn't apply to a vehicle, but number one, it wouldn't be an immunity issue, and we would respectfully submit. And number two, a moving vehicle, it's particularly on a motorcycle or a bicycle. I guess the motorcycles go faster than bicycles. But pretty tough to say to somebody that you've got to see a hole in a road if you're traveling on a vehicle. And I frankly pay some attention to that in my car. With a car, the time you see a hole, it's usually too late to move without taking a pretty good risk of jumping in somebody else's lane if you do see it in time. But it certainly is an argument for another day. We would respectfully submit because we don't think it bears on immunity. I think they cited 60 cases, a little over 61 or something, and they fought it hard, but a lot of that was it was fought on an issue that wasn't involved with immunity. To the very best of our ability, we answered those, but we don't think they're before the court at this time. There's one thing that I think needs to be remembered with respect to negligence. The city found a hole and they made it worse. Not in the long term, but they needed to protect it in the short term and they didn't. That hole in the road, they drilled, they made the hole bigger and inserted a concrete basin in the bottom of it, and with a ring, a metal ring, so they could get the water to go through to test it to see if it was leaking into the sewer with colored water.
That happened after the accident, right?
That happened before.
Before the accident.
And it's strikingly brought out, I think, by in the deposition of one of their workers, the gentleman who was there first, and I apologize, I've lost his name temporarily, but he was the first person there at the scene, and he was the one who triggered the drilling of the hole in the road and inserting the basin, because they wanted to find out if the sewer was involved, and they had to do that.
And that was before the accident.
That was before the accident, and he was the first person to deal with it of any meaningful way.
So were they in
Not
the middle?
with it, but with the hole.
So were they in the middle of repairing it when the accident happened?
No. Everything's shut down for 2 days. I said in a brief that it was Friday to Sunday, and I was wrong. It's Monday to Wednesday. The appellant pointed that out. But actually, it makes it worse because there's going to be more traffic. And there's a picture with that person who found it originally. He's quoted in the brief that he didn't think it was such a big deal. That's not a very accurate way of describing it. But he didn't think it was very serious. But in his deposition, he was shown an exhibit that we would respectfully ask the court to see, and I think it's Exhibit 5G. And it's a photo taken right after the event by Mrs. Elias' husband. And he said, if it had been that bad, I would have done something different. And it's referred to in our brief. When he first got there, he didn't think it was that serious. It was this, it's kind of a slope. It all seemed to go to the center. And they call it, I mean, it would be like a basin from all directions going around a gradual slope into the middle where the water collected. But when he got there, he, rightly or wrongly, he concluded that it wasn't all that serious. But he had not, but after they did the work, and he saw the photo of how it looked, which the court has, he said, if I had known that, I would have done something different. But we respectfully submit that we think it is strictly a case at this point. We think it's a valid case on the facts, but with respect to the law only immunity, we do think that they're definitely not immune. The statute 2744 says they have a duty not to be negligent in fixing the roads, and we think that is where we're at. So, thank you very much.
Any questions?
Okay.
Thank you.
I think I stood up here fairly recently. I know Judge Teodosio was on that panel, and a similar kind of discussion came up in an immunity case. And I don't know if this is a misconception or a misunderstanding about the proving the immunity and proving an exception to immunity. The city is immune, and then the burden of proof is on a plaintiff or a claimant to prove an exception to immunity. Within that exception to immunity, whether it's the proprietary function exception, whether it's the maintenance of road exception, or whether it's the repair of buildings held open for public use, all three of those exceptions require proof of negligence. I'm not sure when it's discussed and claimants say, well, this is only about immunity. You know, hey, I found a proprietary function, you're not immune. Hey, this involved a road and maintenance of a road, you're not immune. Hey, this trip and fall happened in a courthouse or an office building, held open to the public, you're not immune. That's only half the analysis. The other half of the analysis is proving negligence. And when
Didn't
you
the court do that here, though, and found that there were issues of material fact?
on the breach element of negligence, the court did not address the duty elements, and the court did not address what the status of Mrs. Elias was in order to determine whether the duty was breached. It just merely found in a generic sense that there's a question of fact as to whether the city breached the duty. Before you ever get to that, you have to determine whether or not it was open and obvious. You have to determine whether or not there was an assumption of a risk argument. You have to determine things of that nature, the duty elements of it, the open and obvious nature of it. And then, if you find that there's a question of fact as to the breach of duty, you shift to the proximate cause, which is, what was the proximate cause of this? What was the last thing that happened before the accident? It was Mrs. Elias operating her motor vehicle, her motorcycle, over the condition. That was the intervening or superseding cause. Or you have to deal with the comparative fault. Now, I know the comparative fault issue is typically something that goes to a jury, but there is case law out there, and it is cited in our brief, that if a court was to determine, as a matter of law, that the plaintiff was 51% negligent in this case, the court can grant summary judgment on the proximate cause issue. But those are all issues embodied in proof of the exception. Judge Schaefer, repairs had begun at the time of the accident. When I first stood up here at the beginning of my argument, Mr. Green went out to the scene and saw a depression. Based on his highway maintenance experience, he did not believe it posed a threat of harm to motorists. He called the sewer maintenance department and said, you guys might want to come out here and find out if this is sewer related. They drill a hole. It's a small hole in the pavement. In the middle of the depression, they pour dye down there. If the sewer pipe is breached, the dye will get into the pipe and they'll go downhill or down whatever, down flow, and they'll see the dye in the pipe and they know there's something the matter with the sewer pipe. If that never happens, then they know the dye didn't breach the sewer pipe and they know it has nothing to do with sewer. Step one in doing a repair of a depression in the road is determining what's the cause of it. And the city undertook to find out or to determine what was the cause of it right at the outset. After the hole's drilled, Mr. Haslam from the Highway Maintenance Department went out and put the navigator cone, not to mark the depression, but to mark the hole in the road. So motorists wouldn't presumptively drive over this sewer maintenance hole in the road.
So you're talking about a standard triangle type orange cone
Right, correct.
on top of the hole.
On top of the hole. You know, the city of Akron roads aren't perfect. You know, when I got involved in this case, you know, you drive around and you see, you know, you listen to highway maintenance people and they tell you about depressions that exist, and there has to be a prioritizing ones that you know, every one of them can't immediately begin, like Judge Tedosio alluded to, which is hire a contractor or mobilize crews. I mean, somebody has to be vested with the discretion to look at one of these depressions and say, what's causing it? How bad is it? If cars and motorcycles are driving at a reasonable pace, does it pose a hazard to them? And if the answer is no, then you let sewer maintenance or water distribution figure out what's the cause of it, because ultimately that's what's going to happen. They're going to have to figure out, you know, what's the underlying cause of the depression in the road.
Counsel? This is going to put you over your time, I apologize, but there's been almost, I think, the entirety of the focus on the negligence issue here. So we have met the one prong of the statute. You have the immunity, kicks over, there's negligence, but let's just say the court's finding on all that is correct for the sake of my question here. Isn't there then the opportunity for it to switch back to the city? I call it the judgment call part of the statute. I'm trying to find it here and I've been voice.
That's absolutely correct. It's the we call them the O3 defenses. It's O1 definitions, O2 immunity and exceptions, O3 is the defenses that reinstate immunity.
Did the court make any, trial court make any finding on the reinstating of immunity?
It did.
Okay.
It relied on a case called Pointer, an old case that the city was involved in. I don't think the Pointer case is on point. The city had noticed of chuck holes. The city had noticed that the chuck holes posed a threat of harm to motorists, and the city decided to go do another road project instead of filling those potholes. The Pointer court said under those circumstances you can't claim discretionary immunity. What's missing in our case is the city employees and their supervisors did not believe, appear, or appreciate that the depression in the road constituted a hazard like the potholes in Pointer. That's the difference between this case and Pointer.
Didn't the court also cite Shepherd out of the 9?
The court cited Shepherd for, and I don't think it cited Shepherd for the merits of Shepherd. It cited Shepherd because I believe the trial court tried to borrow a theme from an interlocutory appeal where there's been a few decisions from the courts of appeals that have said, since we decided the immunity issue on appeal, on interlocutory appeal, we cannot entertain the common law arguments like duty, breach of duty, open and obvious, and things of that nature. And I believe the trial court cited the Shepherd court for that procedural rule of law, rather than saying the facts of this case are similar to the Shepherd case.
With that, your time is.
With that, thank you.
Gentlemen, thank you very much for your arguments.
Thank you.
We will take the matter under advisement and issue a written decision. It will be mailed to both sides as well as posted on our website and out of the Supreme Court.